all of us, we're obviously recording this from a whole lot of different places, but we would just like to acknowledge the traditional custodians of the land and pay our respects to elders past and present, and also extend that respect to any Aboriginal or Torres Strait Islander people that might be listening today. We acknowledge that this is Aboriginal land. It always was and it always will be. So I will pass over now to our presenters.
Excellent.
Okay,
thank you, Jessica.
That's all right.
So I guess where we should start, guys, is before we dive into the legal stuff, it's a different thing dealing with a client following a natural disaster, isn't it? What are the sort of things you should
maybe I'll kick off. I think that the most important or the most critical thing to always remember when you're dealing with or assisting clients who've just been affected by a disaster is that they're people who have suffered trauma. And trauma manifests in lots of different ways for different people. And I guess one of the challenges in the work that we do is sometimes the way people respond to trauma may present itself in a way that make them what we might consider a difficult client. You know, they don't give you clear instructions. They're a bit muddled in their instructions they do give you. They don't remember a whole lot of things. Sometimes they're just angry. Some clients are just angry and you might think, oh, they're just being rude, but it's just something to be mindful of. It is really just the way they're responding to the trauma they've experienced. I see Paul nodding, definitely something you've experienced as well, I'd say.
Yeah, and the thing about it is not to take it personally. It's not directed at you. It's directed at, I'm in this terrible situation that I don't have much control over at the moment. And that's where the anger and the frustration is directed.
Yeah.
We've seen that a lot, haven't we?
I think one of the things from my perspective, particularly when Paul and I first started doing this work in a concentrated way, was during the 2011 floods. And the stories were really distressing, but the urgency around it and the fact that they wanted something done now, and you're really in a position of having to say to them, this is going to take time, and that you can be the sounding board for their frustration, and you have to also look after yourself to make sure that you can continue to do this work for many months. And clients are very frustrated. And the other thing that we really found was that it was so important to go and see them wherever they wanted you to see them and wherever they were comfortable in seeing you. So in the beginning, we went to where the clients were and where the aftermath of those disasters were.
And I guess the other really important issue in this space is these people are going to be filling out so much paperwork. There's going to be so many trees killed as a result of all the paperwork that people have to fill out following a natural disaster. And if you can minimise the amount of paperwork they have to do for you and ensure that they only have to tell you their story once, that's not only going to benefit the legal side of it, I reckon that benefits the mental health side of our clients too.
For sure. Absolutely, I agree with you. That's a crucial thing about them to tell their story once, if they can. That's incredibly helpful.
And the reason for that is what, Marta? What effect does it have telling the story again and again?
Yeah, so every time they tell their story, one of the things is that they're re-traumatizing it's re-traumatizing them. So it's just a vicious cycle of being traumatized again and again, that they have to retell their story. And sometimes it is helpful to have somebody who's independent of that experience to actually explain it in a way that, you know, those services that they're getting help from will understand it better as well. But yeah, and it's very common because they have to, you know, your clients would have to apply for all sorts of grants and they have to tell their story for that. Then they have to go and seek help from us, and then from their insurer, from whoever else. They have to explain the story again and again and again. So if we can help them at all by reducing the amount of times they have to tell their story, as Paul says, it helps just the bigger picture, and also, very importantly, their mental health and their well-being.
I mean,
I think that's right.
that can sometimes be very difficult. And I know from a solicitor's point of view, or from my point of view, I've had some of these stories repeated to me, and they've traumatized me. So if I'm traumatized by it, can you imagine what they would be going through by having to repeat that?
Mm-hmm.
And it's okay, and this is the other thing that lawyers are bad at. It's okay to seek help if you're feeling a bit traumatized by these stories. Your bosses aren't going to think any less of you if you need to say to them, I need to go and talk to somebody because this has affected me, or I need to be away from this for a couple of hours. Nobody will think less of you for that, and I've done that in the past.
Yeah, for sure. So is there...
Sorry, Loretta, I might just jump in very quickly. Not that I was going to, but we've just been redoing our disaster training for our internal lawyers, and we've just recorded a session with Robin Brady, which many of you may know from your travels, but we've just recorded a trauma-informed practice module that I'm happy to share a link for with people after this session if they want to do a bit more into trauma-informed practice and looking after yourself as well as looking after clients as well.
Yeah, and it's something that you have to revisit, you know, throughout your practice. It doesn't hurt. It doesn't hurt you to revisit that again and again, because you just, you know, it just puts things into perspective, and it's really important to look after yourselves.
And Jessica, is there some way where, how do we go through the slides?
Oh yes, sorry, I was going to say that as well. I've jumped in, so you just let me know. I've just got them on my screen here, so you let me know when you wanted to move around, I guess. But just quickly, I guess this is what the team were going to cover today.
Yeah. Can we just mention that it would be made available, right, Jess?
Yeah, the slides. We're going to look at the slides more as a bit of a handout that people can refer to. So I don't think everyone will be sticking to this potentially too much. This is what we were just talking about here, the helping clients during a disaster. But there'll be a handout, and I'll email those around to everyone that's registered for this today.
Great. Thanks, Jess.
I think we're all happy to receive follow-up questions. If you read the slides and think, oh, they didn't cover that as well as I wanted them to, shoot through an email, and we can look at answering any follow-up questions you have. Although I haven't asked my fellow panelists that, I'm pretty sure they're happy to do that if required as well.
I'm sure.
Yep.
Absolutely.
Cool. All right, so maybe it's a good time then to move to, okay, the disaster's happened. We're looking at making an insurance claim. What do we do? So that's probably that's a good start. So I reckon the biggest problem with this first phase is what we've called in the slides the bush telegraph, but there are variations on it. Following a natural disaster, there are rumours flying around everywhere. And they particularly are related to the insurer says this, the insurer says that, the insurer is denying all claims in this suburb. You would have seen variations in that too, Loretta and Marta?
Oh, sure.
That's right.
And I guess the thing to remember is I'm yet to see a bush telegraph rumour that's right. And when it comes to making an insurance claim, the starting point for any advice is, have you made a claim? If the answer is no, then the first bit of advice is, we're going to ring your insurer now and make a claim. Or if we're in a recovery centre and they're over across the way, how about we walk across and you lodge a claim now? Would that be fair, do you reckon?
I think that, and Paul, we get this question all the time. People say, well, they ask us about whether they will be successful in a claim, and we always say the starting point is the claim. Now, the insurance company, when you ring them, of course they can tell you whether they think your claim will be covered or not, but they shouldn't discourage you from making the claim. And if they are discouraging you from making the claim, or the person that you're assisting, then they should really get some legal advice about that, because they may very well be breaching their code. But the first thing is always lodge the claim. Can't lose, no cost.
And
Yeah,
then Loretta,
I always sorry, you go ahead, Paul.
No, Marty,
I was just going to pick up. Loretta mentioned the word code. What code are we talking about?
the Insurance Code of Practice. So, and I think we'll be referring to that quite a bit throughout this presentation, because it really forms the basis of how an insurance company ought to behave towards its insured. And it represents best practice, and it's actually very easy to follow. Much easier sometimes than the policies of insurance that you get.
I was just going to add that, you know, we're saying that the starting point is to make a claim, and I always say to clients that you can't dispute a decision that hasn't been made. So the only way that you can dispute an insurer's decision is to put in the claim, let them make a decision, whether that decision is to accept or reject your claim, but at least you then have a decision that you can then do something about. So you can't dispute a decision that hasn't been made. Starting point is lodge your claim and get a decision from the insurer.
But I think would it be fair to say some people are concerned that if they lodge their claim, they'll have to pay their excess up front? And is that one of the reasons why they might not be making a claim?
That can be.
Yeah,
but they don't have to pay their excess up front, do they?
That's right.
So
I've
I think
actually
that's,
just had a question through on this as well, that someone has asked, what if clients say they don't want to lose their no claim bonus?
The decision, they're going to have to weigh out what's going to work best for them, because if you don't have a house, for example, your house is a total loss, I think stuffing up your no claims bonus is really not an issue. I think you would be putting in a claim. So they've got to really consider their circumstances to decide whether that is an important thing for them to, you know, to base on their decision on. But for most of the clients that we see after a disaster, they're dealing with lots of loss, large losses, and that question about stuffing up their, you know, their no claims bonus is really never a good enough reason not to put in a claim, in my mind.
the way it comes up for us is that people will think that that the amount of their claim, not in obviously natural disasters, but the amount of their claim will not exceed their excess. And the question that we get is, do I have to put in a claim if there's been a damage, particularly in those circumstances? And of course, you don't have to put in a claim in those circumstances if you don't want to. But it's usually wouldn't be. And in some policies, it's actually you don't necessarily lose the no claim bonus unless it's been a successful claim as well. So it just depends on the wording of the policy, and I'd always want to have a look at the policy before I said, well, yeah, that is a consideration if it's a small amount claim.
Yeah.
Thanks. I have another question
And
that's come from
occasionally,
this. Oh, Paul, do you want to finish off?
I was just going to add, occasionally where this comes from is from call center operators at insurers who the reality is aren't legally trained and will often slip into, we want to help you, so I'm going to tell you as much as I can. And they don't always tell clients the right thing.
So the second question that we've got has come through. So we sometimes see claims refused on the basis that damage was caused by flood rather than stormwater damage. Is there anything we should keep in mind when advising clients to make a claim in those circumstances?
Well, the advice still applies, make the claim. Because when in the 2011 floods, there were a lot of people that were told that it was floods and not storm damage, and that they wouldn't be successful in a claim, and they were, in fact, were. Having said that, there is now a universal definition of flood, which means that it's much more clearer as to whether people will fall in or out of it being flood and therefore excluded, but it still doesn't stop you from making the claim. True, Paul and Marta?
Let's just put this in a bushfire context as well. Where this potentially could arise in a bushfire context is there have been examples where a claim has tried to be denied because embers from the fire came down onto a property that was too far away from the fire. And there becomes a fight about whether it's the fire or whether it's something not directly connected to the fire. I see Marta nodding because you've probably seen the same. And it's a similar type of discussion, isn't it?
That's right.
Yeah, look, and like anything insurance related, it always comes down to the wording of the policy, what you're covered for and what you're not. And what you're looking for is what is the insured event. And for bushfires, that's our starting point is a bushfire. And I always say to people, let your insurer do their job. If they're going to exclude your claim, if they're going to say, we're not going to cover your claim, they have to explain, they have to establish on what basis they're declining your claim, what exclusion under your policy, because all policies are going to be a little bit different, slightly some wording, slightly different. So it's really your insurer's job or the insurer's job to, if they're going to decline a claim, to establish on what basis they're doing that. And then we look into, well, is that correct? A correct interpretation of their policy, and then we look at raising the dispute as advocates for the insured.
And I guess that's a good. Sorry, Loretta, go.
No, unless you wanted to go on to the next slide, because I just wanted to say something more about this slide.
Yeah, no, I was about to head into a discussion about assessors, which are often who insurers use to help them make decisions on their claim.
Well, before we go on to that, I just thought one of the things that I recall, particularly from the floods experience, was that insurers were not making their decisions very quickly and as to what they can do. And I understand there's been some changes to the code in relation to that, about fast tracking of claims. I'm happy to talk about it, because only in the sense that about those emergency, payments in advance if there's urgent financial need, and also in particular whether you ought to make a fast track assessment where there is those sorts of matters. But I don't know if you've got any other perspective on that, Paul or Marta.
Look, I guess the thing about it is always make the claim. If they're taking a long time, ask questions. And if you're in financial trouble, tell them and ask them to move it more quickly as a result of the financial trouble you're in.
Yeah. And insurers have that obligation to provide that assistance under the General Insurance Code of Practice. if your client is experiencing financial hardship, but you obviously need to make that information available to the insurer. So you've got to let them know.
And you can go through the complaints process if they don't do those early assessment and give money in urgent financial need. It would be interesting to see how AFCA deals with those complaints. If they come
the
up
reality, Loretta, we'd be careful there depending on the stress the client's under, because the reality of some of those complaints processes is if you're complaining about them not addressing that, all that does is push out the timeframes for them actually addressing the claim itself.
Yeah,
and that's a decision the client will make.
Yeah.
I think that was exactly the experience that we had in 2011, where clients were very keen to go through the complaints process on a failure to make a decision, and it didn't help them at all, really, in terms of
If I can comment on our bushfire experience, the 2019-2020 bushfire experience when it came to handling of claims. Now, there are still some problems in claims handling, but I think it's fair to say that insurers have been behaving a lot better than they have in the past. And so our experience, sort of just generally in terms of response to financial hardship, is that insurers are handling them appropriately for the most part. But it's always good for you to know that it is something that you can ask for, you can definitely question them about, and they have obligations to assist.
So I reckon that's a good place to move to assessors, because assessors cause our clients stress. That would be fair to say.
Yes.
And I guess the starting point I always say to clients about assessors is assessors aren't perfect. There's this myth out there that assessors are perfect, and when they come to the property, they're going to get everything right. And if I can't convince them right there and then of what happened, I'm never going to get my claim paid. That's a fairly common story I see.
Yes.
People are nodding away again. See something similar, Marta?
Yes, very much so. Sometimes you may have more than one assessor come out to the property. That just goes to show that, assessors aren't perfect. They don't pick it up. They don't pick everything up in the first instance. And sometimes a second or third assessor will be sent out. And some of that could be triggered by, us asking the questions, us saying, we've seen your assessor report, but this doesn't quite cover, our client says there was damage to this part of the house that we can't see that in the report, or, and that could trigger another assessor going out there. And the other thing to be mindful is claims assessors at the insurer, they're also not perfect. So when they assess a report, they could interpret it wrong. So it's helpful for you to also look through it yourself, and don't just take their word as final, because I've raised disputes purely on the fact that the assessment was correct, the assessor's report was correct, but the way the claims assessor at the insurer interpreted the results was wrong. And you raise a dispute on that, change their view of it. So just as Paul says, assessors aren't perfect. I'll also say that the claims officer at the insurer is also not perfect in the way they interpret things. So we're always asking questions, and I think that's a good starting point particularly for lawyers in this space.
And the other important consideration at this point is your client's story, because your client's story of what they saw, what they heard, when they saw it happen, can often inform your review both of the assessor's report and any claims assessor, and will often lead to you raising issues that either gets the claim paid, or, and we'll cover this later, or will eventually win you cases at AFCA if it gets that far, the Australian Financial Complaints Authority, because people's direct experience is as good a evidence as an assessor going out and looking at a property and looking at the damage and looking at its topography and writing a report based on that. Because the advantage your client has is they were there often, or they were there for a period right up until just before the event happened. And that immediacy carries a lot of weight evidentiary-wise.
I think too, the assessors might be relying on third-party information. For example, Bureau of Meteorology information, or information as to when the bushfire service said that the bushfire went through the property. And that can be, so what the client saw, heard or experienced can be relevant, particularly where there's an issue of when the insurance was taken out. It's really important that you try and get them to put that down very early on, because some policies may require a longer period of time before you get coverage, and this might be what the dispute is about.
And just to add to
Well,
what
the
Loretta,
variation on that. Go, Marta.
sorry, just to add to what Loretta is saying about assessors also taking into account possibly third-party accounts of the event. It's crucial to get your clients direct instructions about how they experienced the event or what they saw, because sometimes if there's houses along the road and the assessor has assessed the other houses and they've come to a decision about that, they may try to apply that to your clients, but it's not necessarily the same thing that happened, particularly when you're dealing with regional areas and the houses are so far spread that what happened just to the property, just the very next property, but there's lots of land in between. Whatever happened to that property doesn't necessarily mean it's the same situation for your client's property. So it's crucial to get those instructions from your client.
That was almost word for word what I was going to say. So excellent. We're of a hive mind already, and we're only half an hour into the presentation. Excellent. I guess the other point that's worth making that we haven't made yet about assessors and claims assessors is, again, they're not legally trained. And so particularly the claims assessor is interpreting a complex legal document and applying a complex set of facts to whether the facts are caught by that legal document. And the chances of them making that wrong call are definitely there, because there's plenty of lawyers that look at insurance policy documents and don't understand them either. So we can expect that non-lawyers will make similar mistakes.
Well, they might.
Well, I've seen lawyers on the side of complaints that I've been in make mistakes in interpretation. We're all human.
And my understanding is that the decision about the claim must be made generally within 4 months of making the claim. But if it's an extraordinary catastrophe, it can be within 12 months. I was really interested to read that the extraordinary catastrophe is not something that is gazetted by the government. It's actually something that the Insurance Council board decides whether it's an extraordinary event. So I'm not sure if the bushfires in Western Australia have been classified as classified as an extraordinary catastrophe.
I'm not aware.
That's not something.
But I think
that might be something to check into.
Yeah, I think in the code though talks in sort of general terms about extenuating circumstances that could extend the 4-month decision period to 12 months. So that a catastrophe would fall into that category, but there could be other things like, for example, fraud investigation, which every now and then does pop up, where insurers don't quite believe the claim. So that could potentially extend the time. But having said that, those are timeframes set down by the code, but that doesn't mean that your insurer is allowed to drag their feet for that long. They can't just wait around for 4 months to make a decision. They can't just wait around 12 months to make a decision. They need to take every step possible or necessary to progress the claim in a timely manner. So if that means they've got all the information ready to go, they should be making a decision. I think it's within 10 business days.
That's right.
It's still that. So yeah, there are some time frames where we would, consider whether it's a reasonable time for your insurer to be continuing to decide your claim. But ultimately, regardless of that time frame, if they are just dragging their feet, even if that 4 months isn't up, you could potentially still say that they're unreasonably delaying your claim. So they still have to take every step necessary to progress your claim as soon as possible.
And that's often a good way of forcing those fraud investigations out into the open matter, isn't it?
Yes. That's right.
Because in my experience, insurers will do pretty much everything they can not to admit that they're doing a fraud investigation about a claim.
Yeah, they never quite, they don't always quite come straight out saying it's fraud. They will just continuously say they're looking into it or investigating. But as soon as they start saying investigating, to me it starts triggering, I think they're probably referring to fraud. But anyway, that's just...
Probably a good space to move on to one of the things that I think confuses clients the most, and that's cash settlements, which I think is the next. This is something that consumers always ask about, and I don't think genuinely understand what the difference between cash settlements and getting the insurer to rebuild their property actually means.
Yeah.
So I guess the starting point, is when is it a good idea for a client to say, yes, a cash settlement is something I want? When would you do it?
Well, you don't want to rebuild the property, so you might ask for it. But
and that's pretty common buyers, isn't it?
Yeah, for some clients who have had the worst experience in their life and they don't want to stay in the same area to, remind them of what they've just gone through, they might not want to stay there. They might want to go somewhere else. And so, yeah, cash settlement in that circumstance seems very reasonable to me.
And one of the things that we talked about is that clients can ask for it, but that the insurer doesn't necessarily have to give it. But if and in a sense, you don't really have a right under the contract to or the insurance policy to insist on it either. So, but generally speaking, the experience is if you don't want to rebuild the property, they are quite open to doing a cash settlement. That would be right, Marta, wouldn't it? And Paul?
Yeah.
The other common one is sometimes the damage is partially covered by the insurance and partially not. And so there's a responsibility on the insured who's making the claim to fix maybe part of the house before the damage that is covered can get fixed. Reasonable then?
It's common.
It might, sorry, Marta?
Oh, sorry. There's a slight delay, isn't there? Sorry. I was just going to say in terms of the cash settlement, Loretta, you were saying that it's generally up to the insurer, which is correct. And I think generally from insurers, or sort of what I've heard from the industry, is that generally, even though it's their discretion to decide on how they're going to settle a claim, if your client has a particular request, if they would prefer a cash settlement, whatever, they will generally follow that. And certainly AFCA has taken views around this issue about the insurer's discretion, they take into account, well, you know, whether it's a reasonable decision for the insurer to make. And I'm just thinking of, you know, when you're dealing with, say, an elderly couple who want to rebuild and the insurer wants to do a cash settlement, but this elderly couple just cannot possibly, I don't think it's reasonable to expect that they can manage a rebuild. And in those circumstances, even though the insurer is in their right, essentially under the contract, under the policy, to decide that they'll cash settle it, AFCA has taken the view that in that circumstance, it's not reasonable to cash settle a claim to an elderly couple and expect them to manage the rebuild. So Loretta is correct, you know, they are contractually, they are in their right to make the decision, but there are always ways to negotiate with them or to take the matter further if the circumstances, you know, requires it.
And in fact, Marta, Paul and I had a discussion about this, because the cash settlement often means if the person doesn't want to accept it either, there might be a dispute about all those things. So all those things that we've said where a cash settlement might be reasonable, if the person doesn't agree with it, that's the underlying dispute. So it's not the fact that they want a cash settlement, it's that they don't agree that this sum is reasonable because they actually think it's safe to rebuild, or so it often shows an underlying dispute.
Yeah, absolutely.
An underlying dispute. But
the other lens.
Sorry, Paul.
Look, Loretta, the other lens that's important to put on this discussion, I think, that we haven't spoken about is, remember, AFCA has a fairness jurisdiction.
That's right.
Or a fairness lens to apply to what's reasonable in the circumstances. And so not only is it about looking at what's reasonable in the circumstances, you can also say, okay, is what they're doing fair? Because if it's not fair in the context of the claim, that can also be a basis for a dispute.
That's right.
And that's why Marta's point was so good. That was a perfect example of that, where the fairness of an elderly couple being forced to rebuild their own home is a really nice example, I thought.
I think another thing to point out about, you know, when you're thinking of whether to cash settle or repair is, or let the insurer do the repairer, is the guarantees under the code, the General Insurance Code of Practice about, you know, if your insurer does the repair, then they accept the responsibility for the quality of the workmanship and materials. So, you know, that if there's a problem with it later on down the track that comes up, then you can go back to your insurer and say, hey, your repair work is a bit dodgy, you need to have a look at this and fix it. Now, if you're cash settling, obviously, I mean, the insurer will just, you wash their hands. Once they've cash settled, wash their hands, they're done with it, that's it. Now it's your problem. So you take on that risk. So I always think it is an important consideration for your clients, if they get the choice, to consider. Now, some clients just might want the cash settlement regardless of what you say, but I think it's an important thing to consider is if they've got the choice to cash settle or let the insurer do the repairs, consider that there is that guarantee under the policy. Oh, sorry, sometimes policies itself will say a lifetime guarantee on the repairs, but also there is that backup guarantee under the code that the insurers accept the responsibility for the work.
And the other really important weighing out, Marta, is clients chronically underestimate how much time is involved in, if they accept a cash settlement, in organising tradesmen, organising new tradesmen when the first tradesman doesn't show up, organising tradesmen in the right order so that the work can be done in the right order, being at the property to supervise them. All of that time is not often considered by clients, and when they realise it, they go, oh dear, or that's probably the PG rated version.
Very PG. Yes.
And it's not only about the repairs and seems to, may imply that it's it's finished. It's also when you're not happy about whether they're meeting the scope of works, all those sorts of things, you are responsible for them. And your options then will depend on each state that you're in as to where you can take any complaints. And it's not necessarily free services or free legal action or those sorts of things. So you really want to be careful, because it's not only about guarantees post the repairs, it's also whether they repair it properly in the first place.
Yeah.
And building codes is the other one, isn't it?
Yes.
Oh,
yeah.
Can we go back though? I wondered whether we could just talk a little bit more about mortgages and.
Yes, that's a very good point.
We actually have a separate slide. There's a separate slide devoted to mortgages in about 2 minutes.
Okay, all right. Well, we'll go on to building codes.
Actually, I'll just stop you for a second, guys. We just had another question come through. So I've got, following the 2019-2020 bushfires, we saw a lot of clients making a claim and being paid their sum insured by way of cash settlement the following day. If those clients realise later that in fact they want an insurer rebuild, is there scope to go back to the insurer and ask for this even where the matter has been finalised?
Yeah, I think
Yes.
Go back to the slide, the previous slide.
The previous slide.
The very first one, or
it's you can ask for the no, that's the one. You can ask to have the amount you're paid reassessed, but it's often very difficult to get an insurer to change from a cash settlement to a rebuild.
Yeah. Especially if there's, like, what you would expect in a disaster where there's so many claims. It can be difficult to change the insurer's decision, but the code also provides that after a catastrophe, if a matter is settled, if a claim is settled, I think it's within 1 month of a catastrophe, you've got then 12 months to go back to your insurer to raise any disputes about that settled claim. Although ideally you'd want to do that sooner rather than later. You might have a better chance in getting the insurer to change the decision if you go back to them earlier. Would you say, Paul?
The other problem you risk having in that story is the longer you leave it, the more likely the client is to have spent some of the cash settlement.
Yes, and also potentially another insured event happening.
Yep.
a follow-on question
Agreed.
that we've received, that with cash settlements, should you consider requesting an additional percentage cost as a contingency for the new build?
Absolutely, because insurers typically can rebuild stuff far cheaper than you going out into the market and employing local tradesmen, because they have economies of scale and can get tradesmen to agree to do a bulk of work at a lesser amount.
Yep. And also the chances of uncovering things that maybe weren't seen before when they're writing up the scope of works. Obviously they can, write that up as best as possible from what they see and what they can assess at the time, but invariably there's always something that comes up once they've ripped a wall down or something. They might see something more. So yeah, a contingency amount budget would, look, the worst they can do is say no, right? So definitely ask for it.
And there are actually AFCA decisions supporting us on this view too.
Yes.
There are a number of AFCA decisions where a contingency percentage is written into the decision. So yep. You've got the support of AFCA.
That's right.
And that applies even, and this is a question, and that applies even where they've paid out the whole of the sum insured, because I think that was the question. You got paid, your house was insured for 300,000, it was a total loss, you got paid out $300,000.
It's you can certainly ask for it, but it's harder to make that case where it's a total loss. And Paul, tell me if you think I'm wrong. The sum insured is really your max possible amount you could ever get, essentially, from your insurer, unless there's other build-ins, as in there's additional benefits on top of the sum insured. But generally, your starting point is your sum insured is the max amount your policy could ever pay you, essentially. So when we're talking about the contingency amount, it's more likely that you'll get that when there is a partial loss, or whether they've got to do partial rebuild or something like that, where the max sum insured hasn't been paid out.
And is that even the case?
Or you've got a total replacement.
Yeah. And I'm going to ask a follow-up question, because I think that's possibly what the community workers are saying. Is that even the case? So you've got your $300,000, but the insurance company could do so much more, because like you said, they can employ those contractors at a much lower rate. So you're not going to get as much bang for your $300,000 as would have the insurance company. I'm asking.
That's correct, Loretta.
I want to know the answer.
Yeah, the answer is you get your 300 grand.
Pretty much.
And that's
I think the challenge with that is mostly, and what we generally experience, is that those people are often underinsured anyway, which is why insurers often want to cash settle. Is even if they could rebuild, they couldn't, because they can't guarantee the work. Because they're underinsured. The building codes have changed because of the disaster. Their BAL rating has gone up. And that's often why insurers are quick to cash settle a claim in those circumstances. So I think it's difficult to ask for that contingency amount once you've hit the sum insured. Look, you can ask for it, but I don't think your chances are great. There are policies that have built-in percentage once you've hit the sum insured. They might have like a 10% or 25% or something like that. Some policies have that. Is that, Paul, you've experienced that even? Yeah,
but the reality is the majority don't.
Yeah, that's right.
And it's why you and I have previously discussed how we don't like sum insured in policies very much.
Yeah, if you can get a total replacement, that's your ideal policy.
Yeah, we should clarify though, at this point, we're not giving financial advice in any way.
No,
this is just us talking.
No, that's right. But there are differences in a sum insured policy and a total replacement. Might be very obvious, but your sum insured is really that it's capped at that amount, and it doesn't matter how much more it will cost to rebuild your house once they've paid out the sum insured. That's it. But a total replacement, as it would suggest, could mean however much it costs to rebuild.
Where I have seen sum insured work though is, and this is just a general example, it might be an older couple who's in a really large house, they're empty nesters, all the children have left, and they make a decision, they work out that if something happened, we'd be happy with a 2-bedroom house rather than a 5-bedroom house. And they work out what that would cost to rebuild. And so that's what they do a sum insured for. And if that's the reason they're doing it, then I have no issues. But if it's to try and protect a house that they want to replace, then it's a bit harder.
Yeah.
So I guess a good place, we've probably discussed building codes a bit already. So I guess the place to move to is scope of works, which is the next slide. Where do we start with scope of works?
Oh,
I find scope of work documents really complex
oh yeah.
because they are essentially, I compare them to a job lot for the builder. They're not set up for understanding by a client. They're set up for understanding by a builder.
Yeah.
And not understanding by a lawyer either necessarily.
Also true. So I guess, what are we looking for in a scope of work? Because clients don't understand them. What are we trying to work out? And I guess the first thing to say, and you've covered this a little bit earlier, Marta, is the first scope of works a client gets is not going to cover all the damage because you usually haven't found it all by that point.
Yeah.
And clients don't understand this, do they?
Yeah. I think for me, a very easy indicator to start with is if you've got all of this damage and you get a scope of works that has 3 lines on it, well, regardless of what it says, you're pretty, it's pretty clear that they haven't covered everything. So you go back to the insurer and you say, I've got a whole, like all of this damage, what the heck does this 3 lines mean? Does it cover this? Does it, is it talking about this? And I think it's always important, even if it is, if it seems comprehensive, if there's something that doesn't quite clearly stand out to you, it's always good to have like a log or paper trail of conversations you've had with the insurer asking those specific things. So, if they've got a whole list of living spaces, but your bathroom clearly needs to be fixed and you can't quite make out that bathroom is on that list, then get back to your insurer and say, hey, I've got this scope of list, I don't understand it, but I can't see the bathroom. Can you tell me where it, can you confirm is bathroom included or whatever it might be? So there's some, I've been reading those things for many, many years and sometimes I get them and I'm like, what is that? Does not make sense. But even just something simple like that, where you see it's a very short scope of works, but your client's telling you it's a massive job, and you go back to your insurer and say, please explain this. Doesn't make sense.
Or even tell me which line item talks about fixing my bathroom. Tell me which line item talks about the damage in the garage. Because if they're say they're paying the claim in full and repair, they should know which line refers to which bit's being fixed. And there's no harm in asking lots of questions about it.
Yeah, you want to ask questions about it because you don't want to sign off and agree on something if it's not covered or you're not sure that it's covered. So definitely ask questions.
And can you see?
Does it have to be perfect?
Sorry.
Go, Loretta.
No, you go, Paul.
So I was just going to say, but I guess the thing is, it doesn't have to be perfect before you get them to start work.
That's right.
Another one of those Bush Telegraph issues is my scope of works has to be 100% perfect before I sign off on it and allow the work to start. And all that leads to is delays in the house being fixed.
That's right. Yeah.
Because if other damage pops up, you can get it added to the scope of works. Because as you've said, you knock down a wall and other damage becomes apparent.
Yeah, and a really good example of that, bushfires doesn't quite present the same sort of example, but any damage relating to water, so storm and flood, you really want them to start work sooner rather than later, because once mold hits the place, it's very difficult. Then the cost just blows out of proportion. So yeah, you've got to, it's sort of a balancing act, you know, in terms of what to dispute, what to agree to, get them started and that sort of thing.
So I've popped back with another question, which is great. And everyone keep sending your questions in as they're having this discussion. That's exactly what this platform is for. So this question is, in the past, an insurer refused to provide an itemised scope of works with costs. Is it reasonable to ask them for the cost associated with each item? Any onus for them to provide it?
Depends on the decision you're looking at, as in, if the insurer is going to do the rebuild, then it's not necessary really for you to know the cost of each item. The important thing is knowing what's in the scope, as in what's being repaired, because it's really a commercially sensitive bit in terms of costs, because that's something the insurer will negotiate with the builder. So in that sense, if they are rebuilding, if your insurer is rebuilding, what you're agreeing to is the scope of works in the sense of what's being repaired, not necessarily the cost. You can question it if they're offering you a cash settlement and they're basing their decision on the amount of cash settlement on this quote. Then you could ask them. But again, be mindful of further delays that will cause if you're just holding it up on one small item, you know, again, balancing act.
I'd agree with that.
Agreed.
But you can, of course, if you are unhappy, you can go through the complaints process.
Oh, yeah. Yeah.
But
I mean, you can always complain, really. You can always complain, but you just got to be mindful that it means possible delay of your claim being finalised. But you can always complain if you wanted to.
So the next question we've got that's come through, how do insurers generally treat owner builders? Is that a lot more difficult?
Ah.
Do they? They don't? I don't know.
I don't know. I'd like to know this one in particular, because that's what I will be eventually once I've built my house. So could you answer this one in particular?
So the owner, for me, the owner builder issue, when so long as it's meeting standards, they're going to insure you. And the question then comes, okay, there's damage happened. Does the owner builder want to rebuild themselves, or are they happy for the insurer to employ a builder? That's usually where that argument starts happening, isn't it? And I guess the trap there is, are you comfortable not having the insurer's guarantee on the owner builder rebuild? Or do you want the insurer's guarantee such that if something goes wrong, you've got that protection there? And that's that balance, I guess, between a cash settlement, which they're likely to give an owner builder, and a rebuild, which they'll only do usually if it's not the owner builder doing it, because most insurers have panel builders, don't they?
exactly.
I think the other thing in that scenario would be if an insurer agrees to let an owner builder do the repairs, and you want to continue insurance with them, they will set conditions of when work has to be completed by and that sort of thing. So it might be that, you know, for you to fix the roof, you need to fix it within 6 months, and then you've got to give us guarantees, then you've got to give us all these documents to prove it's been done, and then we'll continue to insure you. So, I mean, on top of that would be whatever your state requirements are if you're doing your own home owner builder situation.
And I guess the risk is, and this is probably a good segue to what Loretta wanted to talk about before, is the presence of a mortgage on the property will often affect that decision as well.
Yes, so we've
Loretta,
had,
do you want to start?
yeah, I'm happy to start the discussion. So it's really, if there's a mortgage on it, you really have to talk to your lender before you accept a cash settlement. And this might be a reason why you want to go to AFCA and say, I definitely don't want a cash settlement. If the lender says, if you accept a cash settlement, we want to pay it onto the mortgage. Now that might be a complaint, even if AFCA decides it's reasonable for the insurer to cash settle it, then what happens with the cash settlement vis-a-vis the lender, that might be a complaint about the lender and what they're doing and whether that's reasonable, and that's an AFCA process in itself. But it's so important to communicate with the lender before you accept it. I think I had a case a few years ago where they'd accepted a cash settlement or been offered a cash settlement. It was accepted, and they still didn't have a house 2 years later. And it was a family of something with 5 children, if I remember correctly. So it was a really bad outcome for the people in that manner. So I think it's really, important that you communicate with the lender in those circumstances.
Just before we move on from the owner-builder topic as well, going back a little bit, but we had another question come through with regard to owner-builders. How does the insurer factor costs for time, labour of the owner-builder to undertake the work? Do they have approved rate?
My experience is they use whatever rate they would be paying their panel.
And it's probably why they're more likely to cash settle this rather than to sort of agree to it, kind of, yeah.
It's in their interest, isn't it, to cash settle?
But on the basis on which they're cash settling, I suppose that's when you would want to know how much they are paying their own panel builders as to what it's going to cost, and perhaps getting quotes otherwise from external builders to say this is what it would cost to rebuild, to make that rebuild.
But that's a good point. Actually, I was just thinking that with the scope of works, they would include in there the labour costs, how long it would take them to do the rebuild or do the repair. So they would already have their report that sets out what the full cost of the job would cost, including labour costs. So if you think it's more, then you would have to get your own report on how, what you'd have to provide some evidence of what would be reasonable in that industry or across the industry as to labour costs for that job. So I think that would be the way you go about that, I think.
I would agree. So, and I guess the other thing.
Move on to the next part, or is there a follow-up question?
No, that was it. Sorry. That was the end of the owner-builder questions for now. Please continue.
I was just thinking if I mentioned about the mortgage. To relate it back to insurance, your insurance policy sets out what happens with a claim once it's been settled, and they generally have a clause in there that says if you receive a certain amount in cash as settlement of a claim, and then if there is a mortgage on the asset, they would first pay the mortgagee before they pay you any residual or any leftover amount. Usually in policies it would be, I think, roughly 20%. 20%. Anything over $20,000, any cash settlement over $20,000, I think, is roughly what most policies have. If you receive a cash settlement of over $20,000 and there's a mortgage on the asset, they will pay the mortgagee first, and then if there's anything left over, then it can come to you. But then that's where what Loretta was saying earlier about speaking to your bank who has the mortgage over your property, speaking to them about whether they'll let you keep the money to do the rebuild or whatever arrangement. I have seen where banks have agreed to let the consumer or your client keep the cash settlement to do the repairs to the property, do the rebuild. Sorry, the repairs to the property mostly. I think the rebuild, they might structure the loan a bit differently. That's I guess definitely a conversation you have with the lender. But with the repairs to the property, I have seen plenty of situations where the bank would let you keep the money to do the repairs. I think maybe it's better for you to keep the house or whatever.
But just be a little.
Sorry,
Go,
Paul.
Loretta.
Yeah, no, I'll come in after you if you like.
I guess the thing to be wary of in what Marta's talking about there is there's been instances where the bank keeps the money and doles it out as the repairs are happening. And the problem with that is sometimes people have tried to save money, say, by painting the inside themselves, and then the bank might refuse to release the money because they're not an accredited painter, just as an example, which can add to the stress of the repairs.
Yeah.
The other thing that I was going to say is if the cash settlement pays out the mortgage, then in that particular circumstance, and there hasn't been an arrangement made, the bank may say, well, you really have to reapply for the loan, or we're going to assess whether you can afford the mortgage. And you might still be paying, you might have paid for years and years this mortgage, no problems, but all of a sudden they'll assess your capacity to pay as against their new criteria, which can be devastating for clients.
Yeah.
So again, it's just so critical to get that sorted, or to have already raised that as a dispute with your lender before you accept the cash settlement.
Had a not so much, I'm not even sure, it might be a question, but I think it's just a very good point here. That's so unfair. Isn't it more important to get a roof over your head than to pay a mortgage?
I think it's a statement.
Agreed.
Yeah.
Agree.
I assume we all just agree.
I agree with you. I can't speak of any matter where we've seen in New South Wales where the bank has been unreasonable. So it's just it's a conversation you have to have with them.
I think it's less likely to happen in a disaster scenario because there's probably more of a spotlight on the actions of the insurer. But I suspect, well, it has come across my desk, but I suspect it's more of an issue when there's one-off events rather than of events. Yeah.
Yeah, I'd have to agree with you on that. Yeah, for sure.
I have seen the odd one, but it's the exception rather than the rule where it goes wrong.
Yeah.
All right, so that's probably all we need to talk about mortgage-wise. I guess the next place to talk is around making a contents claim. And I guess my bugbear around contents claims is when somebody suffers a total loss. And in the past, bushfires, floods, whatever disaster, there have been insurers that have said, oh, hang on, give me a list of everything you lost. I've got a bit of a problem with that. Am I being reasonable in having a problem with that?
Yeah. Yeah, that's reasonable. I have the same problem with that.
Yeah? Tell me why you have a problem with that.
You think of a traumatized person being told, all right, you've lost everything, give me a list. Write down every possible thing you lost in your house. the trauma that comes with that, like it's just insensitive to expect, and it's just not realistic. I think even if I was to write a list of what's in my house right now, I would struggle. I couldn't give an exhaustive list of absolutely everything in my house. And to expect somebody who has just experienced the worst thing in their life, a traumatic event, to sit down and write down a list, it's just it's not reasonable, it's not realistic. They shouldn't have to do that at all. And I think in our recent experience in the bushfires, that hasn't been a problem. Insurers have been really just paying out the contents. But again, that's years of learnings for the industry. They're behaving a little bit better now, but I know back in, Paul and Loretta, you would have had that experience, particularly around floods, when they were asking for people to itemize everything. It was just horrendous.
Happened for a number of years. So it didn't happen in the most recent bushfires.
And the other thing, though, with the partial damage of items and the lists there, people need to be aware that the insurers can then use it as a reason to say that that they won't be paying out all of the loss because there's underinsurance. And that can be re-traumatising for clients as well when they realise that they're not, because some items survive, the insurer might say, well, you had insurance for $50,000, it should have been $70,000. You lost $30,000 worth of goods, we're only going to pay you $20,000. That would be extraordinarily difficult for clients.
It's the same situation as we were talking about earlier with the sum insured of a building. Is same thing that applies in contents. You're looking at a sum insured for your contents, and it's very common for people to be underinsured for their contents as well, because people can't really put a value to what their contents are. And so, they might have had $100,000 worth of contents lost, but they were only ever insured for $20,000. So that would be the max that the insurer pays out, would be the $20,000, which is very sad.
That's is sad when it's a total loss, but I think it's actually worse in some ways if they only insured for $20,000. They lost, 100. Well, they lost $50,000, and but they say, well, that's only half of your contents. We'll only pay you $10,000. That is, I think, a real kick in the teeth for most people. But I agree with you. It's that sum insured.
Similar issues.
Yeah.
Fortunately. But I guess speaking outside of natural disasters for a minute, it's a project for all of us outside of the recovery from the natural disasters to get the community across these sort of ideas a bit better, because while it's improving, most of the community doesn't understand any of this intricacy and technicality associated with insurance. And I see it as part of all of our jobs to change that understanding.
Absolutely. Agreed.
Yes.
It's one of those things where I say to people that unfortunately you do get what you pay for. So just having insurance is not going to be enough. You need to really understand what you're insured for.
And let's be honest, that's difficult for people because I think it would be fair to say no two policies are exactly the same.
Oh, yeah. Very true.
But we won't get me on my hobby horse about standard insurance cover at this point. We'll leave that for another day. Probably a good spot to move to talk a bit about some farmers and farming issues.
Mm.
And my understanding, this is directly relevant to some of the people affected in the most recent fires in WA. And it's a difficult one, isn't it? Insurance-wise, at least.
Yeah.
Well, this is why in some instances, insurance brokers can be very good for people if they have unusual things that they need to cover. And but the best thing always, I always think, is when you're going off to get your insurance policy, you really ought to think about those things that you may need coverage for that you wouldn't need in a suburban house. And a lot of people, particularly living on the fringes of cities, have bigger properties with sheds and farm equipment and fences and animals, like Paul pointed out. And it really is dependent on what's in your policy as to whether there'll be coverage or there won't. But of course, you should always put in your claim.
Just got a question that's come through about this one. Are there any insurance policies that cover loss of livelihood for farmers?
Well, there could always be income protection policies, but again, I always think with those sorts of things, you really want to go off to an insurance broker, and they won't be covered under general policies of insurance, which is what this is about. That's a very specialised type of insurance, loss of income.
That's right. Yeah, there's all sorts of insurance products, business insurance. They really need to sit down. I think I agree with Loretta that I think they really need to sit down with somebody who can navigate that, all those products. But this is really just about general insurance that we're focusing on today. So, yeah.
And dare I say it, Loretta and Marta, they might well have previously obtained business interruption insurance, and that might be being looked at as we speak in the courts.
Correct. Second test case.
But again, that's a subject.
I want to point out with these special type covers, there are just some things that policies just will never cover. These types of general insurance will not cover. Some things might be an optional benefit that you can sort of add on to your policy, but again, it's a conversation they have to have with the insurer. But I was just thinking, in New South Wales, we had a couple of properties where they had bridges on the property, and just as far as I can tell, there is just no insurer who will cover a bridge on residential property. So there are just some things they won't cover. Fences is a massive issue. It was a big problem in New South Wales. Obviously, lots of regional areas, lots of farmland, and lots of people weren't covered for fences, or they were only covered to a certain amount, which was never enough for what they lost. And then in New South Wales, there's some, and I think they might be available in other states as well, but there were some charitable volunteer organisations who were helping with rebuilding fences. They have particular projects that they help out with.
I just had a question come through exactly about this, which is about what if people share fences with shires shared with shires or national parks? Sorry to keep throwing these at you guys.
Now that is
that's
I always like this. I always like this response. Well, that would possibly be a state matter. WA.
The reality, Loretta. Sorry, go. Okay, I'll go. The reality I always have said to people in that sort of scenario is there are often lease agreements or common land use agreement between the property bordering the national park and the farm, which will often deal with things like what happens if there's damage to a common fence, who's responsible for fixing it, and things like that. And so it's often a matter of digging into those property type documents to see whether it's directly addressed there.
I think, though, in relation to national parks, it is usually the owner of the property, but that is something that we could possibly take on notice. That question. Unless you have any other insights, Marla.
Not particularly. I think in New South Wales and the other states might have a similar thing where you have there's a Dividing Fences Act that deals with responsibilities of a shared fence. As far as I know, it does apply in those regions, but I couldn't tell you exactly what happens when you're sharing a fence with a government or state department. So, but yeah, in disaster, that just goes to show that in a disaster you could be dealing with all sorts of law. I mean, insurance is your main one that you'd probably come across, but yeah, it could be council rules and all sorts of things. So be open to thinking like sort of bigger picture of what could be involved.
Absolutely. And I guess something that's becoming more and more common that we're not going to deal with today is often people are looking at rebuilding using tiny houses or movable houses. And the law applying to those is so completely different to the law that might apply to rebuilding a normal freestanding house, arguably.
That's right. Yes. It's an area of interest for me at the moment. We're getting quite a few inquiries about tiny houses. So yeah, it's interesting. It's not, it could be a number of different sort of laws playing into it, but yeah, it's very interesting.
Just before you move to the next topic, I've just got one more question. Will the insurance cover generators?
Depends on the policy.
You would need to check under the definitions of, in a policy, they will generally have like your home, what's defined as a home building that your policy will cover you for, and then in a contents, what is under the definitions, what is defined as contents that you would have cover for. But yeah, that's our standard response is going to be you're going to have to check the policy wording. Every policy is quite different.
Which is unfortunate, but it's what we're dealing with, isn't it?
Yeah. And it can be a challenge, especially when you've got people who live next door to somebody who might have a better policy than they did, and that person might get covered. Oh, my neighbour got all of this done and all of their work has already been completed. And you kind of have to unfortunately go through that conversation of, unfortunately, policies aren't the same, insurers, aren't the same. And yeah, every claim is dealt with by that policy under that particular policy. So.
And I guess the other thing that pops up in that type of scenario about things being covered and not is debris, which is one of the other topics we need to talk about. And I guess the starting point here is there's not really a consistent approach to debris between states, is there?
No.
There's no real consistency between insurance companies or between states. It could be a bit of a minefield. But yeah, so you would have to look at what your policy says about debris. Some policies include it as part of the standard package, some policies don't, and you might be an optional benefit that you've got to tick to include into your policy. depending on the state you're in, they might have, you know, in New South Wales, we had the local government, the state government running a debris removal scheme. But even then, insurers' understanding of how that scheme was to be rolled out was, you know, wasn't consistent, and it was a ongoing conversation, and I think I annoyed a lot of people by continually bringing it up, but I felt like I had to.
I remember those conversations, and they were well justified.
But yeah, it's the starting point, I guess, what we're saying is check your policy to see what it does, whether it covers it or not. And then there's also looking at what state government might be offering at that time. And then good luck, really.
Because I guess the thing not to forget about when we're looking at the state government offerings is they can be really important for people who have no insurance at all or who are underinsured.
Yeah. I'll give an example with the New South Wales scheme. So with the New South Wales debris cleanup, it was that if you had the cover for debris removal in your policy, but the state government had done the cleanup, you were still entitled to be paid out for whatever your policy had in terms of this benefit, which doesn't quite, you know, to lawyers, that sounds like double dipping. But it was the way that the scheme was sort of set up, is that the government was going to come out and do the cleanup whether you had insurance or not. And then the industry had agreed, or at least most of the industry, and they had to sort of filter down the lines, but they had agreed that, and our position is that our client has been paying premiums on a policy that has a benefit that says they're entitled to cleanup. Now, just because the government does the cleanup, we say that our client should still be entitled to the payout, to the amount paid out. The insurer shouldn't be pocketing any savings from that scheme. So that was our position, and for the most part, industry did agree to that. So they agreed to pass on, the insurance industry agreed to pass on any savings they incurred as part of that government scheme. So we found a lot of our clients would be underinsured. I think one of our clients with a payout of the debris removal, which worked out to be a certain percentage of the sum insured. One client, I think they got a payout of about $60,000. Another, you know, we're talking about large, substantial amounts of money that can make a significant difference to these people who are already underinsured. So it's something that you'll need to, if your state is offering this sort of this scheme, the debris removal, consider what you want to raise with industry, because, as I said, our position was always that our clients been paying for this benefit, they should have the benefit of it, and the insurers shouldn't pocket any of the savings. It's better in our client's pocket.
Can I, that's great, Marta. Can I just go back to the fencing issue though? Just as we've been talking, or as you two have been talking, I did do a bit of research, and it is really clear that across the country there are different policies about who will pay for boundary fencing with national parks and between councils. And so it often it's state specific, and in disasters, the government may very well have other policies which might not be the usual policy that they would apply in the usual course of things. So in the usual course of things, they might, you're responsible, or the landowner is responsible for any fencing with the, you know, council land or state government land or national parks. But in disasters, they might have different programs as well.
Agreed. So we've spent already about 90 minutes telling everybody what the problems are and what could go wrong and how to try and deal with it on the insurer. I guess the next step is what happens if the insurer says, no, we're not paying. Can I go straight to AFCA, the Australian Financial Complaints Authority?
No.
As much as I might want to. So what do I do instead, Loretta?
Make a complaint. But I agree, I really agree, it's not, if they knock back your claim, so first you have to get an answer to your claim. They first have to say yes or no. Once you've got a decision, you can go to the internal dispute resolution area, but it really isn't enough just to say I disagree. So you really want a good statement that sets out why you disagree, and it might just be that a statement itself. But this is often where I say to clients, you really want some of your own expert advice if you can get it.
I was just going to add that if you did go to AFCA straight away, AFCA is going to send it back to the insurer and allow the insurer to do an internal review first. So it doesn't really do you much to go to AFCA straight away. So yes, you've got to go through the insurer's complaints. And also, I do tell people that you can complain early, and then you can add to the complaint. A few days later. That doesn't. Basically, you want to start the clock on them reviewing your complaint, because they've got to review their end as well. So as soon as you hear about it, if think about putting in the complaint fairly soon, and then because sometimes getting a report could take some time, and so put in your complaint and say these are the problems, and then get your evidence together and send it through. And adding to your complaint doesn't restart the clock. Your insurer still has to deal with the claim within the time, and if they don't resolve it in that time, then you go to AFCA, then you lodge your complaint in AFCA. Would you say that's right?
I would say that's totally right, and I would be on the lookout for insurers that try and have multiple goes at internal dispute resolution.
Yeah.
They will say they'll have a bit of a look at it, and then they'll want to refer it to somebody else internally to also have a look at it, and then it'll go up the chain further, and they'll refer it back down the chain, and all the while they're still saying no. They only get one go at internal review, and if they internally review it, I don't care who does it, and they say no, that triggers your right to go to AFCA. They don't get 4 or 5 different people that have 4 or 5 different goes at it. They get one go.
And also, if sometimes you have a review officer who does piecemeal requests, so they might ask, I want this document, and then several days later, I want another document, then a week or so later, I want another document. Don't get sort of bogged down by that. If they're not resolving it quickly, either they give you the full list of what they're needing up front, otherwise you've got a complaint that really is an unreasonable delay, they haven't resolved the matter in the time frame for an IDR complaint, go to AFCA. AFCA is a good, some cases a good strategic way of resolving things. Not that we're saying just lodge everything in AFCA, but the AFCA, lodging a complaint in AFCA does prompt insurers to deal with things the way they should be dealing with it in the first place, really.
That's the reality.
Yeah.
The issue, I think, for clients, though, is often that they don't have access to the expert reports, and that can be a difficulty because they can be thousands of dollars. So I think the best evidence that they can get, and it's some independent evidence, is always better than no evidence at all.
Agreed. If you can get expert evidence, that is your best evidence, but if you can't get it, that shouldn't stop you from taking it further. Just gather the best evidence you can and go with your complaint.
And I will often try saying to an insurer, so you got this expert report, and since then there's all this following extra information which that expert report didn't look at, your expert should have another go at this. And sometimes they will redo it.
Yeah.
And also Marta's point that just because the expert, it's the expert assessment might be right, it might just be the interpretation of that report that could be wrong, and this is a good place to raise that. Well, both in the internal dispute resolution phase and also in the phase if you do have to go to the Australian Financial Complaints Authority.
Yep. Now, do you win every case you take to AFCA? We certainly don't. I'm assuming LAQLD New South Wales is in the same boat as well.
Yeah, we don't win them all, even though I like to think we should. Unfortunately, sometimes AFCA doesn't agree with me. I don't know why that happens, but it does. So yeah, we don't win them all, but sometimes even if we don't win them all, it does bring attention to a particular issue, potentially systemic issue. So we might not have the law on our side, but sometimes change comes as a result of us continually bringing these issues up, that if they're a constant problem, then something needs to be done about it.
And in
so let's quickly talk. Go, Loretta.
No.
I was just going to quickly go through the AFCA complaint process just so people can understand it's a multiple step process in resolving these complaints sometimes. And that's this idea that often the AFCA will take a first look at it and issue a recommendation. Now that recommendation is only binding if it's accepted by both parties. If one party doesn't accept it, it then goes to a determination. There are numerous examples where the decision changes between a recommendation and a determination. So just because your client has lost at recommendation does not necessarily mean that they will automatically lose at determination.
And also, I've had cases where the clients have won at recommendation and then lost at determination. So, which is very sad.
And they're cases where the client has chosen to proceed to determination and got a worse result sometimes.
Yeah,
that's true.
It's also though I've seen it where the other party hasn't been happy. So, but when they get to determination, I think the important thing is that consumers do still have the right to take it to court, but the reality of it is that the cost of that is prohibitive. And also, to be fair, there's very few cases where I think, particularly nowadays, where I would assess them as having a better chance of getting a better result through a court process. So I always like to say to clients, if you don't succeed at AFCA, it's very unlikely that you would succeed in a court process.
Yeah, I think that's right.
And
the main difference is AFCA's jurisdiction, the fair and reasonable jurisdiction, which does not apply in courts. So courts are quite restrictive in how they apply the law, whereas AFCA, they do consider the law, they consider precedent, but ultimately, theoretically, they could just throw all that out and say, well, we think that the fair and reasonable way to approach this would be so and so, which is something you generally wouldn't get in court.
That's an understatement, Marta.
Trying to manage expectations.
But that's the important takeaway from what both of you are saying is, in our experience, consumers tend to get much better results from AFCA and its predecessors than they would in court.
Absolutely.
Yes, and it's free. It's free to consumers, and the insurer has to pay for it, which is great.
And that's why you'd want to encourage, I mean, you don't want to encourage unmeritorious claims to go to AFCA, but at the same time, the risks associated with taking a claim that isn't, is more touch and go, you want to take it to AFCA because there's no cost consequences. Whereas if you're talking about court proceedings where there's huge cost consequences, even if they have free legal representation, it's a completely different way as to the way that what you would advise consumers to do about pursuing a complaint.
Yeah, definitely.
I guess before we move on to claims agents, we should check, is there any specific AFCA questions that have come through before we move?
I haven't received any. If you're holding your AFCA related questions, please do type them in now. I'll let you know if any do come through, guys, if you want to keep going.
Cool. All right. Claims agents, some of my least favourite people following a natural disaster. They get it would look for a fee they offer to solve the world's problems. It would be fair to say often, don't they?
Yeah. Some of the things they're promising is that they're promising all sorts of crazy things.
Yep. I think one of the worst I saw was that. You go, Lorena.
No, I was just saying they're very recent phenomenon though. Like they have really ramped up in the last few years because they weren't really around that much back in 2011. In fact, I don't remember anyone making a complaint about them. So it's something that's there's seen as a market for it. And these companies have just jumped into this area and they're extraordinarily expensive.
Yes, very expensive. For those of you who've never come across them, they are the equivalent of ambulance chasers in the insurance industry. I think in the industry they refer to them as storm chasers. And most of them, if not all of them that I've come across, they're ex-insurer employees. So they've worked with an insurer in their previous life and then they've decided to branch out and become an agent, a claim agent. And I've had a recent matter where they did sort of help progress a matter, but at a very big cost. So they were helping a client with an IDR, an internal dispute resolution dispute. So a bit of back and forth with the insurer's review team, and it cost the client $16,000, which is a huge amount of money. And this amount isn't necessarily going to be covered if you go to AFCA. I think there was a recent AFCA matter where they tried to get a claim agent's fees covered and they weren't successful in AFCA. So they're exorbitant fees. They're very, very expensive. I think a lot of them are charging at minimum about $5,000 to even look at your matter, look at your complaint. So it's very expensive.
And some of these companies will do the affected areas. They will come along and actually actively try and recruit people in the bushfire affected area. So please watch out for them.
And they're not, are they usually non-lawyers or they're legal firms as well?
They're usually non-lawyers who have worked in the industry previously. So they do know some sort of inside information based on their experience, but I mean, it's a lot of money. Some of them might charge you a percentage of your payout. And we're talking about clients who need every single cent that they can get from their dispute. And we're talking about amounts that are just crazy. Like $16,000 is what I heard recently, but I have heard a matter, or I read of a matter where the cost was about 50,000, 55,000. So it eats into the any payout the client could potentially get, and it's not an amount that could be covered in the financial loss in AFCA's jurisdiction. So, and again, they write up, I think they write up their service agreements to say that they don't guarantee an outcome, and that's an expensive amount to be paying for. You could lose at the end.
Or nothing.
Yeah. Yeah.
There are some circumstances in more not general insurance claims, but other claims where you might want to get some assistance, but this has become a real problem in this area where the claims are not necessarily complex, but you're being charged an extremely high amount to do what they could do for free, and they could do with or do with a little bit of assistance in terms of legal advice from places like the legal aid commissions or the community legal centres.
Yeah. I think it's just important to note because our disaster clients, they're looking for somebody to help them and, to reduce their stress. They're more susceptible to these types of people or companies who come out and promise them the world that they'll look after everything. So just be mindful if you start talking to a client where they start saying, oh, I've got a helper, they're helping me a lot. Ask them about it. And they, a lot of them, the lady that I spoke to recently, she sort of felt a little beholden to the person because they thought they really tried to help them. But now she's up for a bill, $16,000 bill, which does her no favors at all. So just of it, I think, is a good thing.
And I guess the other thing to say is because of the amount of complaining Marta, I and others have been doing about these agents, the Insurance Council is very interested, ASIC is very interested, other ACCC is very interested. So if you see those types of agents that are causing clients problems, refer them to the regulator.
Yeah. Oh, and at their industry as well, lots of insurance companies are not big fans of these agents. In fact, some of them will refuse to deal with these agents because they think they're a hindrance to the resolution process. So yeah, it's well known, I think, across the industry, and insurers are not fans either.
All right. I think we've made it to our last issue of the. Oh, no, there's a question.
You have, except there's a question that's come through. Are these claims agents obliged to disclose their fees at the beginning?
I'm not aware of any particular obligation other than, your usual consumer law service providing, sort of obligations, but I'm not aware of any particular one that applies to them. Would that be right, Paul, Loretta?
I agree with you.
Because if a particular, if you're a legal practitioner, you have obligations in terms of legal practice and costs agreements, which are different in each state. But if you're not that, then, like you said, it's just the basic consumer agreements, and they're not regulated, so you can't go and complain about them anywhere. So you have all sorts of issues if you're trying to dispute the accounts that they're sending you as well.
Mm.
With a bit of luck, the Banking Royal Commission recommendations that did get through the Parliament that are supposed to start in October might help us around licensing and having a bit more ability to complain about these type of organisations.
Mm. That's right.
Now, I think we've reached our last issue of the training, financial hardship.
Oh, yeah. We did talk a little bit about that earlier, I think.
But the issue often seems to be, particularly about disasters, is what to do with your lender, because you may have all sorts of other costs. You might not have a job, you might not have a house, you might have increased costs associated with the disaster. I mean, it's all the basic sort of, you know, the first thing is that you discuss your financial hardship with your lender, get some advice, and speak to a financial counsellor if appropriate. And if you can't come to an arrangement with the lender, of course, complain to the Australian Financial Complaints Authority. And there might be other things that you're in financial hardship with. So there might be all sorts of other debts that arise as a result of the natural disaster. And again, I think financial counsellors are, of course, a great first port of call.
Definitely. I think that's something that people often forget is, you know, a total loss. If your property is a total loss and you're dealing with your insurer, that doesn't mean you can stop your mortgage repayments. That continues unless you've got an arrangement with your bank. So definitely a conversation that needs to take place quite early on is, you know, they're waiting on insurance, they can't live in the house, but they still have these contractual obligations to maintain their mortgage, credit cards, personal loans, all that kind of stuff. So definitely a conversation to have as early as possible.
And I guess the other point to raise too is banks will forget about the bushfire 12, 18 months down the track, and the financial effects of the bushfire will often last anywhere between 1 to 3 years or longer. And so you might, down the track, in this financial hardship context, have to remind banks and lenders, hang on, this happened, they're still not financially okay.
That's right.
I think that's it now, isn't it? Is that the last slide, Paul and Marta?
There is one final slide that lists some of the relevant general insurance code of practice provisions. And I think a really important part of that started January this year was there's some new provisions around vulnerability and financial hardship that insurers have to comply with. And I would just assume anybody that's been affected by the natural disaster or bushfire is vulnerable, because everybody is.
Yep. I think that's it.
I think that's it. Yeah.
So yeah, that's all the slides we've got. We've still got people online, obviously. We've got about 50 or so people still listening to us. So if you have questions, feel free to type them in now. Otherwise, I will email around to everybody a PDF copy of the slides just for your own reference. This recording will eventually be up on the Legal Aid New South Wales YouTube channel, so we also might be sharing that with some other organisations. So if this is you think relevant for any other organisations, just let us know and we can share that with them. If you do have questions that you don't feel like asking right now, you can send an email through to I know our one is disaster.response@legalaid.newsouthwales.gov.au. And Queensland, do you have an email? I mean, we can share it around. If there's a question that comes through, I'll let you know.
Okay, thank you.
Cool.
But yeah, we haven't had any questions come through, so we've just got a lot of people saying thank you so much, great session, very informative, thank you, lots of this. So I think you've done a very good job, all three of you, and thank you for all presenting and for everybody for attending.
Thanks.
Great.
Thanks, everyone.
Okay.
Thanks,
everybody. Guess we'll wrap up. Bye-bye.